Okay. The committee will reconvene and come to order. And are there further amendments to the bill? Mr. Price?
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will designate the amendment, and the amendment will be distributed to the members, please.
Mr. Chairman, I reserve a point of order against the amendment.
The gentleman from New Jersey reserves a point of order.
An amendment offered by Mr. Price of Georgia.
Mr. Price is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, this is a simple and a common sense amendment that would provide relief from the notification requirements of the WARN Act in the event of a terrorist attack. As you know, under the WARN Act, currently employers must provide a 60-day notification to employees before any closure or mass layoff. The bill that we're debating today extends this notification requirement to 90 days. It also expands the burden on employers by increasing the number of employers and events that are subject to the notification requirements. In the original version of the WARN Act, there were 3 exemptions. One was an exemption for unforeseen business circumstances. 2 is an exemption for faltering companies trying to acquire additional capital. And 3, an exemption for a natural disaster. This amendment would provide for a 4th exemption by providing relief from the WARN Act's notification requirements in the event of a terrorist attack. Mr. Chairman, I would suggest that this additional consideration in the current climate and current potential threat that we face is indeed an appropriate exemption. It provides significant clarification so that employers do not face increased penalties or compliance costs after a terrorist attack. The language is very clear, and it says that no notice under this act shall be required if the plant closing or mass layoff is due directly or indirectly to a terrorist attack in the United States. And I think that one could easily see, given the events on 9/11, of a possible scenario where significant effect to a business establishment that was distant from the terrorist event could occur and result in significant challenges for that employer. So I would suggest, Mr. Chairman, that this is a wise, prudent, common sense amendment. I would hope that we'd be able to adopt it as the bill moves forward, and I yield back the balance of my time.
I thank the gentleman. Thank you for his explanation of the amendment. As the gentleman notes, this is a response to the times we find, and if there's no objection, the amendment's agreed to. Is there any objection? No objection.
Mr. Chairman, just the record, I withdraw my point of order and
excuse me.
do not object to your unanimous consent request.
If there's no objection, the amendment is agreed to, and the amendment is agreed to. Are there further amendments to the bill? If there are no further amendments to the bill, the question is on this. The question comes on the substitute.
Oh, wait.
Oh, I have a technical correction. I'm sorry. The chair recognizes himself for an explanation. Through clerical error in the material on page 12, line 17, and through line 5 on page 13 were inadvertently included in the text of the substitute, and I move to strike that text. Recognize the gentleman from California, Mr. McKeon.
Mr. Chairman, reserving the right to object, and I do not intend to object, but I would like to note for the members that we only received the original bill 8 days ago, the substitute last night at 7 o'clock, and now we have another change that is going to be made. You know, when the original WARN Act was passed in 1988, it was a result of many hearings, years of discussion, a presidential veto, and finally it was gotten right. My concern is, much as with much of the legislation that we've had before this committee this year, it's come at very short notice. It's been pushed through very quickly, and my concern is that when we take shortcuts on the process, we end up causing unintended consequences. And I'm concerned of other things that might be in this bill, that if we had regular order and gone through the hearing process and had a chance for people to explain potential problems with this bill, we might have been better off. Under that, I would reserve my objection.
The chair thanks the gentleman for his remarks. If there is no objection.
One other thing, Mr. Chairman, I would like to ask that you would explain this correction.
Yeah, this was an amendment that, as I explained in my opening statement, to my surprise, provided for taking money, I believe, from H-1B visa fees and using it to help people pay for COBRA, which I object to. As members of the committee know, COBRA is a plan where you can continue your health care coverage, but you must pay the employee share, the employer share, and a 2% administrative cost of that plan. And the idea that we would now suggest that there would be government funding for some recipients of that plan, certainly without hearings or anything else, was objectionable to me, and I'm sorry that was included in the legislation. So I asked to withdraw it. If there is no objection, the language is stricken from the bill. The question comes on the substitute as amended. All those in favor will say aye. Aye. All those opposed, no. No. In the opinion of the chair, the ayes have it. The ayes have it, and the substitute is agreed to.
And then we'll have final
Yeah. I'll now entertain a motion by gentlewoman from California, Ms. Woolsey.
Mr. Chairman, I move that the Committee on the Education and Labor report the bill to the House of Representatives with an amendment in the nature of a substitute, with the recommendation that the amendment be agreed to and the bill as amended do pass. The question,
The question is on favorably reporting the bill. All those in favor will say aye. Aye. Those opposed, no. No. In the opinion of the chair, the ayes have it. The ayes have it. Mr. McKeon. Mr. McKeon requests a roll call vote, and the clerk will call the roll.
Chairman Miller.
Aye.
Chairman Miller votes aye. Mr. Kildee.
Aye.
Mr. Kildee votes aye. Mr. Payne. Mr. Andrews. Mr. Andrews votes aye. Mr. Scott. Mr. Scott votes aye. Ms. Woolsey.
aye.
Ms. Woolsey votes aye. Mr. Hinojosa. Mrs. McCarthy. Mrs. McCarthy votes aye. Mr. Tierney. Mr. Kucinich. Mr. Wu. Mr. Wu votes aye. Mr. Holt. Mrs. Davis. Mr. Davis of Illinois. Mr. Grijalva. Mr. Bishop of New York. Mr. Bishop of New York votes aye. Ms. Sanchez. Mr. Sarbanes. Mr. Sestak. Mr. Sestak votes aye. Mr. Loebsack. Ms. Hirono. Mr. Altmaier. Aye. Mr. Altmeyer votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Mr. Hare. Ms. Clark. Ms. Clark votes aye. Mr. Courtney. Mr. Courtney votes aye. Ms. Shea Porter. Ms. Shea Porter votes aye. Mr. McKeon. Mr. McKeon votes no. Mr. Petri. Mr. Petri votes no. Mr. Hoekstra. Mr. Castle. Mr. Souter. Mr. Ehlers. Mr. Ehlers votes no. Mrs. Biggert. Mr. Platts. Mr. Platts votes no. Mr. Keller. Mr. Keller votes no. Mr. Wilson. Mr. Wilson votes no. Mr. Klein. Mr. Klein votes no. Mrs. McMorris Rogers. Mrs. McMorris Rogers votes no. Mr. Marchant. Mr. Price. Mr. Price votes no. Mr. Fortunio. Mr. Bustani. Mrs. Fox. Mrs. Fox votes no. Mr. Cool. Mr. Bishop of Utah. Mr. Bishop of Utah votes no. Mr. Davis of Tennessee. Mr. Davis of Tennessee votes no. Mr. Wahlberg. Mr. Wahlberg votes no. Mr. Heller. Mr. Payne. Mr. Payne votes aye. Mr. Hinojosa. Mr. Hinojosa votes aye. Mr. Tierney. Mr. Kucinich. Mr. Kucinich votes aye. Mr. Holt. Mrs. Davis. Mrs. Davis votes aye. Mr. Davis of Illinois. Mr. Davis of Illinois votes aye. Mr. Grijalva. Mr. Grijalva votes aye. Ms. Sanchez. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Ms. Hirono. Mr. Hare. Mr. Hare votes aye. Mr. Hoekstra. Mr. Castle. Mr. Castle votes no. Mr. Souter. Mr. Souter votes no. Mrs. Biggert. Mrs. Biggert votes no. Mr. Marchant. Mr. Fortunio. Mr. Bustani. Mr. Bustani votes no. Mr. Cool. Mr. Heller.
How's Ms. Hirono
Ms.
recorded?
Hirono is not recorded. Ms. Hirono votes aye.
Are there other members that seek to be recorded? The What's the count? The clerk will announce the vote.
Mr. Chairman, 24 members vote aye and 17 members vote no.
And the bill is agreed to, and H.R. 2796 is favorably reported to the House, and the chair notes the presence of a quorum. For the information of the members, we will now move to the consideration of H.R. 3685, and we will debate and consider amendments on the legislation. We will roll the votes during that time, and then we will call for the votes in the passage of the bill at the same time, and we'll try to notify members' offices. You want to be recorded? We have Mr. Holt would like to be recorded. I ask unanimous consent that he be allowed to be recorded, since it will not change the outcome of the vote. Pardon? And Mr. Fortunio asked to be recorded. No, Mr. Fortunio. And I ask unanimous consent for that, since it will not change the outcome
Mr. Chairman,
of the vote.
with that, I would like to be recognized as a yes.
As a yes. Ms. Sanchez, you're recorded late, but the gentlewoman asked unanimous consent to be recorded aye, and I ask that to be allowed, since it will not change the outcome of the final vote. You're clear over here? Okay. The committee will now proceed to consideration of H.R. 3685, the Employment Non-Discrimination Act of 2007, and I yield myself for the purpose of an opening statement. Today, the committee will consider H.R. 3685, the Employment Non-Discrimination Act, which will bar employers from discriminating against their employees on the basis of sexual orientation. The legislation ensures that employment decisions are based upon merit and performance, not prejudice. Today will mark the first vote ever taken on the Employment Non-Discrimination Act in the House of Representatives since the Non-Discrimination Act was first introduced. It never should have taken over 30 years to get to this point, but I'm proud that we are considering this important civil rights legislation today. No federal law addresses discrimination based on sexual orientation. 30 states permit employers to make critical employment decisions based solely on the employee's sexual orientation. In those 30 states, employers can fire, refuse to hire, demote, refuse to promote employees on the basis of sexual orientation alone. Last month, the Health, Employment, and Labor Pension Subcommittee heard testimony from Michael Carney, a highly decorated police officer. Officer Carney was initially denied the opportunity to return to his job with Springfield, Massachusetts Police Department because he was gay. Fortunately, Massachusetts is not one of the 30 states to deny the basic rights to gay workers, and Officer Carney was eventually able to return to his job. This was not the case for Brooke Waits, who also testified at the hearing. Ms. Waits was fired from her job in telecommunications after her employer discovered that she was a lesbian. Since the state of Texas allows employers to fire workers based upon sexual orientation, Ms. Waits had no recourse, and she could not get her job back. It is hard to believe that otherwise fully qualified, bright, and capable individuals are being denied employment or fired from their jobs for these completely non-work-related reasons. This is profoundly unfair and indeed un-American. Unless we act to outlaw this discrimination, untold numbers of American workers will continue to go to work each day with the legitimate fear that they could be fired or wind up unable to provide for themselves or their families. That is why it is essential that Congress act to protect the rights of all workers, regardless of sexual orientation. Specifically, the Non-Employment Discrimination Act extends employment non-discrimination protections to gay, lesbian, bisexual, and heterosexual people, prohibits employers, employment agencies, and labor unions from refusing an individual by using an individual's sexual orientation as a basis for employment decisions such as hiring, firing, promotion, or compensation, prohibits employers from subjecting an individual to different standards or treatment based upon an individual's sexual orientation, provides the same procedures for grievances as Title VII, the employment discrimination claims, but somewhat more limited remedies than permitted under the Title VII of the Americans with Disabilities Act. It exempts religious organizations from coverage under the Act, and it covers businesses with 15 or more employees, as well as employees in the public sector, and it does not allow for quotas of preferential treatment and does not allow the Equal Employment Opportunities Commission to collect statistics on sexual orientation or gender identity or compel employers to collect such statistics. A 2007 Human Rights Campaign survey found that 90% of the Fortune 500 companies have already adopted sexual orientation non-discrimination policies. Indeed, many major American companies, including General Mills, Cisco Systems, Kaiser Permanente, Microsoft, Citibank, Morgan Stanley, and Time Warner, have expressed their strong support for legislation that outlaws discrimination on the basis of sexual orientation. I am encouraged to see that these businesses have proactively adopted policies to ensure that they are able to attract and retain the best and most qualified employees. While this is an encouraging trend, our entire workforce and our nation's competitiveness will benefit from making sure that every state and all large workplaces are covered. I would like to recognize the leadership of Representatives Barney Frank and Tammy Baldwin over these many years on the Employment Non-Discrimination Act, and it is because of their tireless effort that we are finally here today. Finally, I would like to express my deep gratitude to the many individuals and organizations around the country that have long advocated for legislation to guard against discrimination on the basis of sexual orientation and gender identity. And I strongly support this legislation we are considering today, and I urge my colleagues to vote for it. And with that, I would like to recognize Mr. McKean, the senior Republican on the committee.
Thank you, Mr. Chairman. I thank you for yielding. The bill that we're poised to consider, the Employment Non-Discrimination Act, has been introduced in the U.S. Congress in various forms and fashions for some 20 years. In fact, it's been introduced in differing forms 3 separate times this year. To date, it has not been enacted. I believe this is at least in part because the legislation raises several complex questions about how it would impact employers, whether it would encroach on employee privacy, and how it comports with existing anti-discrimination statutes. In September, we held the first and only hearing on this topic. We looked not at the bill being marked up today, but at a previous version of this legislation. During that hearing, experts cautioned that some provisions in the bill could be confusing, difficult to comply with, and potentially fraught with litigation. We need to consider whether the same would hold true for the bill before us. More fundamentally, I believe we still have not addressed the most fundamental questions about the legislation itself. Why are we creating a new anti-discrimination policy outside the long-standing framework of Title VII of the Civil Rights Act of 1964? Have we considered how the specific language of this bill aligns with existing federal, state, and local mandates? And what about the ambiguous language that remains in the bill before us? Under the bill, we would legislate a prohibition against employment discrimination because of an individual's perceived sexual orientation. This vague term is not defined anywhere in this bill, increases employer liability, and will needlessly require litigation on the meaning of this term and how it applies to the workplace. For example, anyone of any sexual orientation can claim to have been discriminated against because of their perceived sexual orientation. How does an employer credibly refute that accusation? Should employers begin keeping records of their perceptions of employees' sexual orientation? Also importantly, the term is not contained in the existing civil rights statute that protects against discrimination on the basis of race, color, religion, sex, or national origin. This raises a question as to why it should be included in this bill just for cases involving sexual orientation. I do not believe that such a radical departure from the Civil Rights Act is justified. I also have concerns about the application of this bill to religious organizations, particularly schools. Under Title VII of the Civil Rights Act, the unique standing of religious organizations is recognized through the broad protection of their hiring prerogatives. Because this bill was crafted as a standalone measure, it is not entirely consistent with these existing protections for religious organizations. For example, under the bill, religious schools, colleges, and universities are only included if they are controlled, managed, owned, or supported by a particular religion, religious corporation, association, or society, or if their curriculum is directed toward the propagation of a particular religion. There are some 900 colleges and universities in this country that describe themselves as religiously affiliated. Of the 102 institutions that are members of the Council for Christian Colleges and Universities, nearly 1/4 are identified as having no official denomination affiliation or religious affiliation. Would these religious schools be covered under this bill's requirement of a particular religion? This is just a sample from a single association of colleges and universities. The number of schools excluded from the religious exemption may be much larger. The name of this bill incorporates a principle to which I am sure we are all committed: employment non-discrimination. Yet, despite the good intentions of those who support this proposal, I believe there is still too much uncertainty and too many unanswered questions. As with any new federal mandate, we must thoroughly and thoughtfully consider both intended and unintended consequences of this legislation. We must ask whether these policies are consistent with existing local, state, and federal mandates, and whether they would place undue burden on employers or employees. Members on our side of the aisle may offer a series of amendments that will illustrate the challenges inherent in this bill. I urge members on both sides of the aisle to give these amendments the full consideration they deserve. During a single subcommittee hearing on this topic, experts raised key questions that I believe have not yet been fully answered. As such, I cannot support this bill. I yield back the balance of my time.
The gentleman yields back the balance of his time. I thank the gentleman for his statement. The clerk will designate the bill.
H.R. 2685, the Employment Non-Discrimination Act of 2007.
I ask him to ask consent to dispense with the reading of the bill, and without objection, the bill is considered as read and open for amendment at any point. The bill has been distributed to the members. Are there members that have amendments?
Mr. Chairman,
Yes, Mr. Sauter.
I have 3 amendments at the desk. I'd like to start with the one on perceived.
Mr. Chairman, I reserve a point of order against the amendment.
Gentleman from New Jersey reserves a point of order. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you. My amendment is very simple. It strikes the word "or perceived" each place it appears. I believe the bill overall is unfixable and uniformly bad. I believe it can never address fairly the questions of religious discrimination, whether it's with colleges, schools, Christian bookstores, Christian organizations that have playing music at exercise centers that are not affiliated with the church. The bill is unfixable. Nevertheless, there are a few things not in the direct religious area that are incredibly bad. Although I understand that some people believe that perceived is necessary if you're going to have desired employment protections for sexual orientation, if we're to have any bill. I offer this amendment to highlight why this bill is fundamentally flawed, because sexual orientation is not the same as race, gender, or age, which do not depend on perception at all. This is a possible litigation nightmare where perceptions are enough to cause lawsuits, resulting in a hostile work environment for those with moral or religious concerns regarding homosexuality. I mean, what are you going to have? A code of things that some people perceive as homosexual? Are you going to have a list provided to employers to say certain colors of things? Everybody knows that people of diverse sexual orientations come in all types. So how in the world do you not label certain types of behavior as perceived in order to know whether there's discrimination that it's perceived, when in fact anybody who studies this realizes there are all sorts of homosexuals, male and female, of all types. So in order to have perceptions, you have to kind of have a bigotry watch list that an employer somehow could stumble into, or an employee could stumble into, because it's perceived that the person is homosexual. This is an incredibly bad piece of litigation, potentially endless litigation. It highlights the whole problem with trying to litigate something like this, and I just believe this amendment by any reasonable person should be adopted, because if we get into the whole question of what's perceived, we are going down a incredible legalistic nightmare. Yield back the balance of my time.
Chairman yields back the balance of his time. Mr.
Mr.
Andrews.
Chairman, I ask recognition.
Gentleman is recognized for 5 minutes.
Speak in opposition to the amendment. One of the unfortunate characteristics of bigotry is the use of stereotypes, where people objectify people and describe them by perceived characteristics rather than by taking a person for whom he or she is. There are numerous stereotypes that attach to prejudice against based on sexual orientation. Here's the set of facts that this bill is trying to deal with, and they, I think, explain why Mr. Souter's amendment ought to be defeated. Let's say that we have an employer who, in fact, is bigoted against gay men. And this employer has on his or her mind a list of stereotypical qualities that gay men demonstrate. I think we've all lived long enough to understand what some of the consensus is those qualities, what they are. They're bigoted stereotypes as to what, quote, someone looks like if they're gay, close quote. So the employer fires the employee based upon his reaction to those stereotypes. The employee sues to get his job back because he wasn't fired because he's not a good fireman or police officer or bank teller or computer programmer. He's fired because his employer thinks he's a gay man. If he's not in fact a gay man, if the record would show that in fact he's a heterosexual who's effectuated whatever stereotypes this employer thinks makes him, quote, look like a gay man, close quote, if he lives in any one of 30 states, he has no legal protection to keep his job. If his argument is he was a victim of gender discrimination, he wasn't, because he wasn't discriminated against because he's male. He wasn't male enough, I guess, in this circumstance. It wasn't because of his race. It wasn't because of his ethnicity. So the idea here is not to simply protect someone against the fact of their sexual orientation preference, but against the bigoted interpretations that some people, happily I think a minority of people in society, would demonstrate. Now, the argument that this somehow creates a lot of confusion and a torrent of new litigation, there's an extremely analogous situation in the Americans with Disabilities Act. Although the word perceived is not used, the concept that if someone is discriminated against because they appear to be disabled in some way, they are protected under the ADA. I don't think the record shows, and the gentleman from Indiana can tell me if it does, but I don't think the record shows there's been any flood of litigation based upon this principle that's in the Americans with Disabilities Act, that if someone effectuates the mannerisms of a person with a disability and is discriminated against on that basis, they're protected under the ADA. I think the same principle will apply here. And I think if you get fired as a firefighter or as a bank teller or a computer programmer because of someone's perception, particularly if it's an inaccurate perception, that you should enjoy the protection of the law. For these reasons, I think Mr. Souter's amendment should be defeated.
Will the gentleman yield?
I'd be happy to.
As you so well said, the word perceived isn't in ADA. But my question is that does the gentleman have a list of what would be perceived, or is this totally up to the judgment of the courts as to whether it was perceived? Because
Well, reclaiming my time, what will happen, Mr. Souter, is if people are dismissed from their jobs or not hired in the first place because the reason is discrimination, yeah, the litigation of those cases will bear that out, and it should. It should. If people are being dismissed or not promoted or discriminated against because of a perceived sexual orientation, I think the law should protect them against that. I would continue
Will
to
the
yield.
gentleman yield? Because my question is do you have a idea of what this would be? Because in effect, you're saying if the person isn't gay, but it might be dress or how they talk.
Well,
and
reclaiming my time,
is that
Mr. Souter, here's
that
what
protected
happened.
now?
If an employee, as the firefighter who testified here in the hearing, testifies that his job evaluations were uniformly excellent, that he did everything the fire department wanted him to do, and all of a sudden one day he winds up getting fired or demoted, and the record is bereft of any reason as to why that was, and he's able to develop evidence, he has the burden of proof. If he's able to develop evidence that shows that discrimination based upon a perceived characteristic, that's where your list will come from. I hope it never gets generated, because I hope what happens is employers don't do that. And this law would be a deterrent against that, which is why we should
Will the
defeat
gentleman
your
yield for one more question?
my time is up, but if the chairman permits me, I will.
Gentlemen, yeah.
Why do you say the burden of proof lies on the person? Because he has the benefit of the law by saying perceived is illegal, so he just has to raise doubt.
No, the burden of proof is on the plaintiff in this case to show he was the victim of discrimination. If the employer raises this as an affirmative defense, then the burden's on the employer, but the burden rests with the plaintiff in this matter.
Gentleman's time expired. The others who seek to be heard on the amendment? If not, the question comes on the amendment. All those in favor will say aye.
Aye.
Those opposed, no.
No.
The noes appear to have it. The noes appear to have it.
On that, I would like a recorded vote.
The gentleman asked for a recorded vote, and the recorded vote will be ordered. It will be postponed in accordance with our agreement. Are there other amendments to the legislation?
Mr. Chairman, I have a second amendment at the desk.
Mr. Souter is recognized for.
On the
Gentleman
one
can
on
identify the
Mr.
amendment.
Chairman, I reserve a point of order against the amendment.
Gentleman from New Jersey reserves a point of order. Are the clerks clear about which amendments being?
marriage.
An amendment offered by Mr. Souter of Indiana.
So we're handing out the right amendment here? Okay. The gentleman is recognized for explaining this amendment while it's being distributed.
Thank you, Mr. Chairman. This amendment is also simple. It strikes paragraph 3 of Section 8A. This amendment protects the sovereign right of states to preserve and protect their respective definitions of marriage and to prescribe benefits and privileges that devolve from the enjoyment of the marital estate. The amendment preserves the right of employers to establish and maintain nepotism rules common throughout commercial industry. The amendment preserves the right of employers to condition employment upon being married. For example, many group homes for at-risk youth hire married couples to live in the homes with the children. This would be prohibited if you banned marriage as a criteria. The amendment protects the right of employers to maintain moral standards for their employees based upon marital status. For example, an employer may want to discourage extramarital sex or sexual relations outside of wedlock. This amendment would ensure an employer may do so. It's a simple amendment, but makes one's position very clear and how far-reaching and prejudiced this amendment is against those who differ with the goals. Yield back.
Mr. Chairman,
The gentleman yields back his time. The gentleman from New Jersey.
I seek time in recognition of the
Gentleman's
opposition to the
recognized for 5
amendment.
minutes.
Thank you. I would urge my colleagues to oppose this amendment. If this language that is stricken by this amendment is not in the bill, frankly, there's an easy roadmap for people who want to continue the legalized discrimination against gays and lesbians and bisexuals. And it's simply to adopt a policy that says you can only get a job if you're married. Because in 49 states, gays and lesbians cannot marry, as we meet here. So you could come up with all sorts of reasons why discriminating in favor of married people was a good thing to do, and you would be insulated in that decision. It would simply be a proxy to continue to discriminate against those who cannot marry. I think what's necessary to protect here that's a fundamental unfairness is if you take a social status and make it a precondition to getting a job, and then you tell certain members of the population they can never achieve that certain social status because it's illegal for them to get it, you're defining them out of ever getting the job in the first place. So again, if you're a firefighter and you live in one of the 30 states that has no protection in this instance, and your state, and this would become law with Mr. Souter's amendment attached to it, and your state then adopts a policy that says all firefighters have to be married. Well, then if you are a gay or lesbian, you can't be a firefighter because you can't get married. So this subverts, I think, the basic intention of this bill is that people should be judged upon how good a firefighter they are, or how good a bank teller they are, or how good a computer programmer they are, not whether their sexual orientation fits some perceived social norm. So I would urge that the amendment to be defeated because I think that its adoption would subvert the purposes of the bill.
Will the gentleman yield?
I would.
Does the gentleman agree that this would applies as the way I said, that it would prohibit group homes from having marriage criteria, that would restrict other types of sexual guidelines that a Christian business might have?
Would the gentleman restate the question?
In other words, I said that, for example, group homes often have husband-wife criteria that they be married. Christian businesses often have standards on extramarital sex or other things.
Well, reclaiming my time, I think the gentleman's really asking two questions. If he's asking whether this fits within the religious exemption, he hasn't really given us enough facts. But if he's asking us whether an employer putting aside the religious exemption could say you have to be married to work here, yeah, the amendment says you can't do that, or rather the bill says you can't do that. But I think your hypothetical poses questions about the religious exemption, which, for the record, is the religious exemption that's existed under the employment discrimination laws in the country since they were adopted. There's nothing new about the scope of this religious exemption. It's what we've lived with for decades.
Will the gentleman yield?
I will.
So I take it that, for example, Christian bookstores, which are not covered by the religious exemption, and that by anybody's standard, for-profit Christian bookstores and group homes that aren't part of a church would not be covered, that the gentleman's answer was yes?
I do not accept the premise of the gentleman's question because he hasn't given us enough facts to determine whether his bookstore is truly a religious organization or not. So I would not answer his question because I think it's not factually developed, and I'd yield back the balance of my time.
Question comes on the amendment. All those in favor will say aye. Aye. Those opposed, no. In the opinion of the chair, the noes have it.
On that, I'd like a recorded vote.
The gentleman asked for a recorded vote. Recorded vote will be ordered. It will be held until the end of the consideration of the legislation.
Mr. Chairman, I have one more amendment at the desk.
Mr. Sauter is recognized for his third amendment.
Mr. Chairman, again, I would reserve a point of order. And
Gentleman
for the
recognized,
record, I would have withdrawn my points of order on Mr. Souter's first two amendments.
Thank you. And the gentleman reserves a point of order. Mr. Sauter is recognized for 5 minutes to explain his amendment.
And let me read this one because it's not complex, but a little more lengthy than just eliminating a section. This is a protection for religious freedoms. Number 3, refuse to express or provide written or oral consent to a covered entity's anti-discrimination or anti-harassment policy, or refuse to participate in a covered entity's diversity training program because such policy or program imposes a substantial burden on the individual's sincerely held religious beliefs regarding sexual orientation. This is a very narrowly crafted amendment. We looked at multiple different options, and it merely ensures that the bill gives similar protections to employees with sincere religious objections to homosexuality as it does to employees who support homosexual behavior. It does not protect religious speech in the workplace. One of the problems with this provision in the bill is that it tilts the law in favor of those who endorse homosexual behavior and puts potential punishment on those who don't. It will pit the employee's religious freedom against sexual freedom, again creating the potential for a hostile work environment. Now, there are all sorts of angles that can come up here. Obviously, already under law, without this bill, you can't create a hostile work environment for somebody who is homosexual. What this is that, for example, if you have a Bible, if you refuse to go, if you even express your views not on an individual basis, can you be prosecuted for harassment? And that I believe if a bill is going to protect the rights of those who speak out for homosexual whose behavior does that, there ought to be, for those who have a deeply held religious view, the ability at least not to have interpreted that you won't go to a diversity course or certain kind of non-directed, because we all agree the current law already says you cannot harass in the workplace. There have been multiple rulings that say intimidation of somebody for their viewpoints are already banned, that this is a question of whether we're going to go actually reaching even farther to discriminate against people who oppose homosexuality. I yield back.
Mr. Chairman,
The gentleman yields back the balance of his time. Gentleman from New
I
Jersey.
seek time in recognition of, in opposition to the amendment. I continue to reserve my point of order.
And gentleman is recognized for 5 minutes.
First of all, with respect to the gentleman's statement that somehow the underlying bill propagates favoritism on behalf of gays and lesbians and bisexuals, that's simply not true. This is a neutral piece of legislation. It says that gays and lesbians and bisexuals must be treated in the work environment the same way everyone else is. Decisions must be made based upon the merits or demerits of their performance. The bill expressly states that quotas are not required. You don't have to make some special effort to hire a certain number of people who fit a certain category. This bill is all about equal protection of the law and neutrality in the eyes of the law. Now, with respect to the question of an employee who feels discomforted by the idea that he or she has to sign a anti-discrimination policy, anti-harassment policy, or attend a diversity training program, let me be very clear. If signing such a statement or attending such a meeting is used as a means of harassment against that employee, and he or she is denied a job or denied a promotion or treated unfairly in some way, that is religious discrimination protected under Title VII. So if an employer were to say, you know, Mary over there refuses to come to the diversity training seminar because she's a bigot, because her faith teaches her to be a bigot, that is discrimination against someone based on their religion, and it's illegal. On the other hand, if an employer says, look, we have customers and we have employees of all different types. We have people who have different religious views, different racial backgrounds, different political views, different sexual orientations. And for our business, we think it's very important that people learn how to understand each other and get along with each other. So we're going to make it a condition of employment that someone understand our ground rules for learning how to interact with other people. Not only is that's not required by the bill, but it's certainly permitted by the bill because it's not discrimination based on religion. So I would be very clear that if someone is singled out for harassment or unfair treatment, that is religious discrimination. It's illegal under Title VII. But it's certainly not religious discrimination or illegal under Title VII for an employer to say, we have lots of people coming into our business, we hire lots of different kinds of people, and it's important to us for the success of our enterprise that people learn how to appreciate each other, respect each other, and get along with each other. If this amendment were to be adopted, I think it would strip from businesses the ability to do that, and for that reason I think it should be rejected. And I would yield back.
The question comes on the... yes, excuse me, Mr. Hoekstra.
Thank
Gentleman is
you.
recognized for 5 minutes.
At this time, I'd like to just yield a couple of my time to Mr. Souter.
I ask unanimous consent to insert into the record how sexual orientation and non-discrimination laws harm businesses and employees. An AT&T employee in Denver was fired for refusing to sign a company-required pledge to recognize, respect, and value sexual orientation differences within the company. A man was fired by the American Red Cross for not celebrating homosexuality. He said that he was not comfortable going to Gay and Lesbian Pride Month, and they were urged to observe, so he was fired. In the AT&T case, he wouldn't sign the AT&T broadband employee handbook, which with policies conflicted with his religious beliefs. This bill would nationalize what is happening at the local level and pit, with the balance going to the pro-homosexual side, many Christians who while they'll be quiet, they can't go around harassing others, aren't even going to be allowed to hold their religious faith.
Will the gentleman yield?
I'll be happy to.
Will Mr. Huckstra yield? In those cases, Mr. Souter, did those individuals file suit based upon religious discrimination?
I don't know the answer to your question, and I apologize, but I do know this, that this bill will make those cases, if they were not overturned, much more difficult.
Thank you.
Yeah. Yield back the balance of my time. Thank you, Mr. Chairman.
Question comes on the amendment. All those in favor will say aye. Aye. Those opposed, no. In the opinion of the chair, the noes have it. The noes have it.
I'd like a recorded vote.
Gentleman asks for a recorded vote, and the gentleman from New Jersey removes his point of order. Is that?
I do, in fact, remove my point of order.
Thank you. That vote will be held until into the consideration. Mr. Hoekstra, you have an
Thank
amendment?
you, Mr. Chairman. Mr. Chairman,
I'm sorry, Mr. Walberg. You wanted to speak. The chair apologizes to the gentleman. Yeah, Mr. Hoekstra.
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will designate the amendment, and the clerks will distribute the designated amendment.
And Mr. Chairman, I reserve a point of order against the amendment.
The gentleman from New Jersey reserves a point of order.
An amendment offered by Mr. Hoekstra of Michigan.
The gentleman from Michigan is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. I offer the amendment to improve the flawed religious exemption included in the bill before us today. Religious schools and universities not affiliated with a particular religion or denomination would not be exempt from making employment decisions on individuals whose behavior runs counter to the mission of their institution. Religious daycares, elementary schools, high schools, and colleges are some of the institutions that will be subject to substantial litigation to determine whether they qualify under the current bill's definition. If enacted, the law would contradict the moral principles of these institutions and allow the courts to determine their mission. INDA invites the government and courts into schools. The bill leaves the courts to determine whether a school's curriculum is sufficiently religious. Government curriculums wouldn't stop at No Child Left Behind. The amendment I offer would broaden the religious exemption by changing the definition of religious organization to include educational institutions that maintain a faith-based mission. The amendment allows schools to preserve their religious tenets and mission, stops government intrusion that is not under their purview, and prevents lengthy and expensive litigation for the schools. With that, Mr. Chairman, I'll yield back the balance of my time.
The gentleman yields back the balance of his time. The gentleman from New Jersey.
Mr. Chairman, I ask recognition to oppose the amendment.
The gentleman is recognized for 5 minutes.
I thank the chairman for yielding. One of the most difficult things we have to do here is balance the rights under the First Amendment of religious freedom of expression with other values and priorities in society, such as the avoidance of employment discrimination, fairness in the workplace. For more than 4 decades, we have struck a balance as to where that ought to be with respect to discrimination based on race or national origin or gender or religion itself. And this amendment strikes a different balance. We don't really know what it means because it would be tested and litigated. What we do know is that the language in the underlying bill strikes precisely the same balance between religious freedom of expression and our value of non-discrimination that has been struck for over 4 decades under the law. There are times when this is a difficult balance, and there are times when it must be litigated and disputed. But I think by and large the balance has been struck correctly, and I think subverting that balance would be a mistake. On that basis, I would oppose the amendment. I would yield to my friend from...
Mr. Chairman, I would add that the definition used in the bill is taken from Title VII, for which there has been extensive litigation. So we know how it is defined and have decades of litigation to define it. If you have a different definition, you start that litigation process all over. So I would hope that we'd keep the definition as it's been in Title VII and yield back.
If I may, I appreciate the gentleman's leadership on this issue. Frankly, he is the gentleman in the Congress to whom I would most readily turn for advice on the proper scope of this subject. I know he thinks deeply about it. I respect his views, and I thank him for his input. Mr. Chairman, I would also withdraw my point of order and yield back the balance of my time.
Question comes on the, yes, excuse me. Did they want to speak at this point? Well, I thought they want to speak after the amendment. Okay.
After the amendment.
Mr. Wahlberg, gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I would certainly hitchhike on this amendment in support of it. I have with me just 2 letters from faith-based organizations. One, Spring Arbor University, which is connected with a denomination. The other being Wheaton College, one of my alma maters, along with former Speaker Hastert's, as well as Jim McDermott's alma mater as well. So you can see there's some diversity in Wheaton College. And yet, they have taken a very strong stance against this legislation because of the issue of mission. Mission and purpose that they have held long and strong and consistent. Not opposing diversity, but having very clearly defined beliefs and principles that they adhere to and expect all who are in their employ to adhere to as well and sign on, and thus have been able to continue strong educational policy and commitment to fairness, justice, and even diversity. This language that is in the bill would cause extreme concern, problems, and probably litigation to a school like Wheaton that is not tied in to a specific denomination, but is independent. It would cause significant problem to religious bookstores whose main purpose does not come under the Title VII language, to the Boy Scouts, religious daycare centers, religious summer camps that have clearly defined missions and purpose that don't intend to discriminate in any way, shape, or form except to carry out their purpose in a justifiable way. For us to step in and produce litigation responsibilities for them that will be costly, that will take away from their impact upon lives of people who have been positively impacted for decades, is the wrong way to go. I think that Congressman Hoekstra's amendment is very realistic, very reasonable, and very narrow, and will meet needs that, frankly, in the future, we'd be glad to see as well. I think of universities and schools that have mission, that include gay and lesbian lifestyles and support of and encouragement of, that would run a risk under this bill if reverse litigation were to take place, saying that because someone was hired and ultimately changed their position and now stands in opposition to the mission and purpose of that school, they indeed would run the same risk that a Wheaton or a Spring Arbor University or a religious summer camp or the Boy Scouts of America would come under. So I would encourage my colleagues to look very deep and strong and ultimately very just and support this amendment.
Will the gentleman yield?
I'll yield.
Thank you. Thank you, Mr. Wahlberg. You know, the more I hear on the debate that's going on in front of us today, the more disturbed I become. This bill is an aggressive attack on people of faith and faith-based institutions in this country. Not every faith, but certain faiths. And we better think long and hard about the impact that we're going to have on one of the pillars of what has made America a special place, religious freedom. This is government starting to aggressively dictate and start saying what is appropriate and what is not appropriate in certain faiths. And that is a scary, scary thought. Thank you. Thank the gentleman for yielding.
And thank you, Congressman. I agree strongly with what you've said. It is a scary thought that we're moving that direction. We are speaking here of thought crimes. We are speaking here of change agentry that goes way beyond the purpose intended for this liberty that we enjoy so much in the United States. This is not a vindictive attack against this legislation, but I think it's a reasonable approach to say, with a diversity of opinion, yet there is still a foundational truth that many of us hold very dear and important. And I again encourage support of this amendment. Thank you, Mr. Speaker.
The gentleman's time has expired. The gentleman had correspondence. He'll make those available to the clerk that he wanted included in the record. I would also ask unanimous consent to make available for the record a letter received from the General Conference of the Seventh-day Adventist Church and the Union of Orthodox Jewish Congregations of America and the U.S. Conference of Catholic Bishops, in which they say, by including the language, the religious exemption in the legislation that is consistent with the religious exemption language in previous Congresses, we believe that the religious liberties guaranteed by the U.S. Constitution, Supreme Court jurisprudence, and existing federal law are better protected, and we urge you to oppose any amendment that would upset that tradition. Mr. Holt, seeking recognition.
I move to strike the last word. Thank you, Mr. Chair. I just wanted to take this opportunity before debate is over to make the point that this is really an uncommon opportunity to provide fundamental protection of individuals. When we know that there is a group in need of fundamental protection, we shouldn't let that opportunity pass. Or, as our colleague John Lewis often says, it's always the right time to do right. I think that that it is incumbent on us to have comprehensive protection. I'd like to point out that in New Jersey, we have in law protection against transgender discrimination. It passed the New Jersey Assembly by a vote of 69 to 15. This is strong protection. It is the kind of thing that should be national. Furthermore, I would like to see the federal employees in my state held to the same standard of protection that private employees are at companies like Johnson & Johnson and Merck and Pathmark and Toys R Us and a number of others. They have policies against discrimination on the basis of gender identity. This is a rare opportunity. We shouldn't let it go by. Thank you, Mr. Chairman.
Thank you. The gentleman yields back the balance time. Mr. Ellers.
Thank you, Mr. Chairman. First of all, I strongly support the Hoekstra Amendment as well as the Souter amendments. But let me also express a bit of frustration that this appears to be a partisan issue. It isn't. It shouldn't be. I think there are a number of people on this side of the aisle who would be happy to protect the rights of those of various sexual orientations from discrimination in the workplace. But the majority seems determined to write the bill precisely to satisfy their own purposes, their own constituencies, and leaves us in a terrible position of saying, well, we really support the concept of the bill, but we can't accept some of the specifics. This is a very important issue that I think should be addressed properly and in a conciliatory fashion, not just within this committee, but within society as a whole. And so I support the concept of what's trying to be done here, but I certainly can't support the means by which it is being done. And that leaves me, and I suspect some of my colleagues, not just in this committee, but in the entire Congress, very uncomfortable with the bill in the sense that it doesn't really do the job the way it should be done. And I had to express that concern because I think it's an extremely important issue. It's one that has to be addressed in our society. People have to be treated fairly and properly regardless of sexual orientation or what my colleague from New Jersey calls gender identity. I don't think that's the issue. The issue is the details of how this is to be done and how it is to be handled in the large number of situations that occur in our society. And it's not easily made into a one-size-fits-all mold, which is precisely what's happening in this bill. So I would encourage a good deal more consideration and discussion and debate on this issue before we ram it through and send it to the floor. I yield back the balance of my time.
Mr. Chairman. Thank you, Mr. Chairman. I yield my time to Mr. Andrews.
I'll be very brief, Mr. Chairman. I thank my friend for yielding. I don't want the record to be left with my friend from Michigan's comments that this is an attack on people of faith. Nothing could be further from the truth. This is no more an attack on people of faith than the civil rights statutes of the 1960s were, that said if you're an African American or if you're Italian or if you're a woman, you can't be discriminated against in the flow of our economy. At that time, the Congress struck a balance between the rights of religious organizations and our opposition to that kind of invidious discrimination. That is precisely the same balance struck by the bill that is before us today. This is no more an attack on anybody's position of faith than those statutes were that we have lived under for over 40 years.
Will the gentleman yield?
I will yield when I'm finished.
Thank you.
And what I think is different about this is that just as in the 1960s, the suspect class, the rabble-rousers, were people of color and people of certain faiths and women, now this is yet another unprotected minority. But I want to be very clear about this. The language that protects the religious exemption is exactly what we have lived under for over 4 decades. If you think that we've had an attack on people of faith for the last 4 decades, then draw that conclusion. But I think the record shows exactly the opposite is true, and the record should not reflect that here. It is Mr. Bishop's time to yield, but...
And I will yield to Mr. Hoekstra. Was it Hoekstra?
Mr. Wahlberg?
Mr. Wahlberg, was it?
Was it Mr. Wahlberg?
Yes. Would you? Thank you. Thank you so much. I appreciate the comments being made here about the comparison to the civil rights gained rightfully so for women, minorities. But a very significant difference lies here. Some religious individuals who misguidedly took positions against minorities or women's rights, at the very least back then, did not have the backup of evidentiary principles and documents that gave them the right to take those wrong positions and evil positions. We all come with filters in our life. I have filters. Each of us do. A filter that I have is scriptural authority. Now, other people would say that authority isn't the authority that they would take. But here we're talking about scriptural authority related to lifestyles that I don't just surmise and say women or minorities don't have the rights that men and whites do. That had no backup in the mission, the purpose, and authority that I take as a filter in my life. What this goes on and says that I can't take that scriptural authority to mean what I believe it says in long-held position. And I think that's where it differs, and I respectfully want to point that out and make sure that that's a part of record, that this is an issue of justice and freedom for religious beliefs that are long-held and mission of purpose. Thank you.
If I still have time remaining, I'd like to yield to Mr.
Just to conclude, and I respect the gentleman's views as well, but I would again say that when people of like mind want to associate freely and practice a faith based on those principles, they have the right to do so under the exemption that's created here. And I yield back to Mr. Bishop.
Gentleman yields back his time. Mr. Bishop.
If I have time remaining, I'd like to yield to Ms. Woolsey.
Ms. Woolsey. You got 58 seconds.
All right, I can do it in 50 seconds. In response to this being an aggressive attack on the religious, people of faith, scriptural authority, all I can say is imagine how gays and lesbians and bigender people have felt from real discrimination all of these years. And think about that when you're making this vote. Thank you, Mr. Chairman.
Balance of his time, Mr. Souter.
Thank you, Mr.
Gentleman's
Chairman.
recognized for 5 minutes.
First, if what's been said that the religious exemption covers Christian colleges, then I would assume Mr. Hoekstra's amendment will go by voice because it's already law. But in fact, I don't believe it is already law, and this bill would change the balance of that, which is why the amendment's needed and why it's being resisted. It's also been troubling to me as someone who, to be open about this, had a Christian bookstore as part of a larger operation, was not covered by a religious exemption because it was a part of a for-profit business, who's been to Christian booksellers conventions with thousands of people. To say that we're not sure it exists shows an incredible lack of information about members in their districts. The whole growth of the parachurch movement, which are not directly oriented and owned or part of a particular denomination, has mushroomed all over the United States. To see the Christian business directives where people, what do you think Chick-fil-A is closed on Sundays? Are we going to force them to be open? There are businesses that have deeply held Christian views that are not covered. And the reason we view this as aggressive is that you are moving into an arena that hasn't pitted fundamental, foundational principles of many denominations, if not most of religions of the world, and it is an aggressive assault on their freedom to practice their religion, and even a resistance to changing perceived, saying that you can't have a husband and wife be an example in group homes, to not provide any whistleblower protection, to be against Mr. Hoekstra's, states how far, in our opinion, this aggression has gone. I yield to Mr. Hoekstra.
Yeah, I thank my colleague for yielding. Let's not say that this bill includes the language of Title VII. It includes the language of Title VII 2000E-2, which is a very narrow definition of religious institution. It forgets the section above it, which says, shall not apply to an employer, and then it goes on, to a religious corporation, association, educational institution, or society with respect to the employment of individuals, or to perform work connected with the carrying on by such corporation. This is a much narrower definition in this bill than what you find in Title VII. And I just want to get that on the record. Thank you, Mr. Souter, for yielding.
I yield back.
Gentleman yields back his time. Mr. Kucinich. Gentleman's recognized for 5 minutes.
I thank the chair. In listening to this debate, it occurs to me that it would be instructive to go back to the First Amendment itself and to remember that it says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So there was a balancing that took place that certainly creates for successive Congresses a challenge in trying to balance the protections that are accorded to religion. It's freedom of religion. It's also freedom from religion. And so we can, at the same time, recognize that the framers called for separation of church and state. But when you look at the first framed document, the Declaration of Independence, and you listen to these words, it's very clear that they didn't call for America to be separate from spiritual values. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. Now, when you listen to these words, when they said men at that time, we know today that it doesn't just mean men. We know that it doesn't just mean white people. We know that it doesn't just mean straight people, that it means all people. And so today, when we're confronted with this legislation, we should be mindful that discrimination of any kind is un-American and should not be tolerated. I stand with the principles of the LGBT community to defend against discrimination on the basis of sexual orientation and gender identity. Harassment, intimidation, and discrimination of anyone in the workplace is unconscionable and it is un-American. And all employment decisions should be based on individual performance. So we have to stand firm, I believe, with all Americans in recognition that discrimination against any member of the LGBT community is discrimination against the entire community. I yield back.
Gentleman yields back his time. Ms. Fox, recognized for 5 minutes.
Thank you, Mr. Chairman. I want to say that some issues have been raised by the Christian schools in North Carolina that I have to share with the committee today. And I want to say, in terms of Mr. Kucinich's comments, I think it's always good to go back to our original documents, but too often the second part of the First Amendment as it relates to the statement on religion is often forgotten. That part is usually left out when people quote that. So I'm pleased to hear him bring it to everybody's attention. The new language in H.R. 2685 defines religious organizations in part as an educational institution controlled or supported by a, quote, particular, unquote, religion. But since certain, as it's been pointed out before, faith-based institutions may not be affiliated with a particular religion, the language raises a question as to the breadth and applicability of the exemption. And there may be an argument that the exemption here is not as broad as that found in Title VII has been brought up. So schools that are not directly associated with the church are still at risk. The definition of religious organization does not adequately cover religious schools that are not, quote, controlled, managed, owned, or supported by a particular religion, religious corporation, association, or society. And the American Association of Christian Schools, I think, put it best, saying this ambiguity leaves a substantial loophole for litigants to bring suits against religious schools regarding employment practices, placing religious organizations in the same uneasy waters as other language has. This bill presents no meaningful protection for religious organizations such as schools, and I'm very concerned about it. Thank you, Mr. Chairman. I yield back.
Gentleman yields back the balance of the time. Mr. McKeon, gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. It's obvious that we have a different understanding of Title VII, and the bill's exemption for religious organization, as is in the law before us, fails to protect the hiring prerogatives of religious schools. The bill fails to clearly adopt the existing exemption for religious organizations that's contained in Title VII of the Civil Rights Act, which is the thing that Mr. Hoekstra was referring to. Anything short of the long-standing protections in Title VII is an inappropriate infringement on the hiring protections afforded to religious schools. And although it's been claimed that H.R. 3685 provides the same protections for religious schools as Title VII of the Civil Rights Act, the bill does not do so. And I have a letter I want to put in the record from the Council for Christian Colleges and Universities, Paul Courts, the president. His final paragraph states, "I urge you to remove the complicated religious definition language currently in ENDA and ensure that this act categorically exempts religious organizations as in Section 702A of Title VII of the Civil Rights Act of 1964 as amended." Also, I'd like to put in the record numerous interested parties that have explained their religious exemption in H.R. 3685 as insufficient, including the aforementioned Council for Christian Colleges and Universities, the Agudath Israel of America, American Association of Christian Colleges and Seminaries, Inc., American Association of Christian Schools, the Family Research Council, the Ethics and Religious Liberty Commission of the Southern Baptist Convention, and Traditional Values Coalition. I yield back the balance of my time.
Gentleman yields back the balance of his time. The question comes on the amendment. Mr. Davis.
Thank you, Mr. Chairman. Listening to this debate sort of reminds me of my parents, who had not spent a great deal of time studying philosophy or the Constitution, but they did teach us one basic thing, and that is, do unto others as you would have them do unto you. something called the Golden Rule. I happen to believe that the most basic of all human desires, the most basic of all human desires, is the desire to be treated fairly, with respect, with equal opportunity, and with equal protection under the law. And that is not one segment of the society. That is not one group of individuals. That is all human beings, no matter what their gender, sexual orientation. They want equal protection under the law, and it is our responsibility to provide equal protection under the law. And I yield back.
The gentleman yield.
The gentleman yield to
Yes, I'd be pleased to.
I always like to hear your eloquent statements, and I love to hear your voice. And I agree with what you said. The problem that we're grappling with here in this debate is that when you strive to protect some people, you take away protections of other people. That is the difficulty. And I think that some of us on this side are representing some of those people that feel like, as good as your intentions are, you're taking away some of their rights in their religious beliefs and in their dealings on a day-to-day basis. That's what is causing the problem and why the difference in the debate. I yield back.
And reclaiming my time, I'll just simply say that they also taught me that if you begin with a faulty premise, in all likelihood, you're going to reach a faulty conclusion. And so if you believe that rights must be balanced, then you work with the issue and the situation until you reach that point where you are certain in your mind that you have balanced the equation, and the ultimate answer is still equal protection under the law. And I yield back.
Mr. Scott.
Thank you, Mr. Chairman. I move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you.
On the
Mr.
amendment.
Chairman, extending civil rights is extremely important, but I have to register my concern with the language in Section 6 as it is currently written. The debate so far has suggested that the religious exemption is not broad enough. In fact, the exemption in the bill is actually broader than the Title VII exemption. The definition of a religious organization is the same, but the coverage of the bill exempts more than Title VII exempts. The First Amendment to the Constitution states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. It is this last clause that we are addressing now, prohibiting free exercise. It is for this reason that Title VII extends to religious organizations an exemption from enforcing civil rights laws in order to respect their right to practice their religion. But it necessitates, therefore, that the purpose of their exemption be not only that they are a religious organization, however you choose to define that, and in this case it's already quite broadly defined, but that in Title VII, the reason for their exemption, the reason they do not need to enforce basic rights asserted in the law, has some religious rationale. Prior civil rights laws provide us legal guidance on this matter. Now, Title VII of the Civil Rights Act of 1964 states in relevant part that it shall not apply to a religious corporation, association, educational institution, or society with respect to the employment of individuals of a particular religion to perform work connected with the carrying on by such corporation, association, educational association, or society of its activities. Courts have interpreted this as not only looking at the employees or potential employees' religion on its face, but also at their practices and whether or not those are in accordance with the teaching and tenets of the employer's religion. Similarly, the ADA states that the Act shall not prohibit a religious corporation, association, educational association, or society from giving preference to employment to an individual of a particular religion to perform work connected with the carrying on by such corporation, association, educational association, or society of its activities. Moreover, it contains an explicit religious tenets requirement that states under the Act that a religious organization may require that all applicants or employees conform to the religious tenets of such organization. In contrast, the exemption in Section 6 of the bill is flawed because it creates an absolute right for the religious organizations to be exempt from enforcing the rights of a class of people that we're seeking to protect by passing the bill. This absolute right does not require any religious rationale, as in the case of Title VII. It does not serve to protect the free exercise of any religious scripture, teaching, tenet, or belief. Rather, we're allowing a religious employer, simply by virtue of being religious, to be exempt from the law. Without basing this exemption on the right to free exercise, a religious organization does not and should not have the right to discriminate against an employee or potential employee. There is no legal rationale for this exemption as currently written, and we're therefore creating a new right, but at the same time exempting a whole category of employers from adhering to it. Mr. Chairman, the right to an exemption for religious organizations exists under Title VII, but only when it is based on the principle of free exercise. But unfortunately, the language in Section 6 does not require that basis. We're setting an unfortunate precedent with the bill as written, and it is my hope that the chairman and chief sponsor of the bill will correct this flaw in an otherwise monumental piece of legislation as the process continues by more closely conforming the religious exemption to Title VII and the legal precedents established over 4 decades. Mr. Chairman, I would therefore oppose the amendment and hope that we can actually tighten the amendment as the process goes forward. I yield back.
The gentleman yields back the balance of time. The question comes on the amendment by Mr. Hoekstra. All those in favor will say aye. Aye. Those opposed, no.
No.
No. In the opinion of the chair, the noes have it. Noes have it. The gentleman from Michigan asked for roll call. The roll call vote will be provided for. We have a couple people who want to speak. Ms. Woolsey, do you still seek recognition?
Mr. Chairman?
Are you seeking recognition? Are you seeking
Yes, I would.
Yes. The gentlewoman's recognized.
Okay,
For
I
a
just
quick
want,
5 minutes.
Thank you very much. And before we have our final vote, I'd just like to say that my constituents oppose this bill because it doesn't include gender identity. In fact, the only letters and emails and faxes we've received, and there have been hundreds of them, have said, Congresswoman, don't vote for it unless it includes gender identity. But I believe, like you believe, that bringing and your commitment to all of us that we will bring an amendment to the House floor so that we can vote to include gender identity. I believe that is the positive way to address the situation. I will be voting today, but I want you to know the people I work for in the 6th Congressional District would rather I voted no.
I thank the gentleman. Ms. Clark, did you seek recognition?
Yes, I do, Mr. Chair. Thank you.
The woman is recognized for a quick 5 minutes.
Thank you very much.
Votes coming on the floor and.
Yes,
Thank you.
I got the notice.
Gentlewoman is recognized.
I speak on behalf of the Americans who've been left out of the protection of this legislation, H.R. 2685. This legislation is incomplete. This bill, I believe, should not pass in its current form since there are still serious issues to be resolved, namely the exclusion of gender identity from the bill. For decades now, gays, lesbians, bisexual, transgendered Americans have bound themselves together in a struggle for basic human rights and equal protections under the law. More than 300 LGBT organizations have united and expressed their opposition to the exclusion of the transgender community, and by extension have asked that this bill not move through this committee excluding transgendered individuals. A 2004 survey sponsored by Human Rights Campaign showed that 70% of the GLBT community asked that gender identity protections were an important part to this bill, and that they would rather not see it pass than have transgendered individuals left out of the legislation. In my home district in Brooklyn, New York, we have local laws which protect both sexual orientation and gender identity. Just this year alone, states as diverse as Iowa, Colorado, and Oregon have also passed laws which protect sexual orientation and gender identity. I have certainly struggled with this issue, Mr. Chairman, as you well know. Like many communities in my congressional district, the LGBT community has been historically and institutionally and categorically denied equal protection under the law. And I fear that by passing H.R. 2685 without protecting transgendered Americans, we leave those Americans vulnerable to the types of discrimination and bigotry that have plagued this nation for so long. So in closing, I would just implore my colleagues that the passage of this bill excluding transgendered Americans sends the wrong message to those who would seek to do harm to those Americans and could have unintended consequences. I yield back.
Will the gentlelady yield?
Yes, I will.
I wish to associate myself with Ms. Clark's remarks, and because I believe that we could have done better in this committee today by having a more inclusive end of bill, I will not be voting for this bill today, and I yield back.
Mr. Chairman, I also will not be voting for this bill today, but I yield back the balance of my time.
Balance of her time. Ms. Shays Porter.
Thank you. My religion tells me that I should love everybody and protect everybody. This has been very difficult for me. I will vote for this, but on the floor, and only because on the floor, there will be an amendment, which I intend to vote for also. This has been very difficult, but thank you for the work that you've done, Mr. Chairman, and I will be voting yes.
Thank you. The gentlewoman yields back her time. Mr. Payne.
Yes, I'd like to also indicate that I wish the bill included all persons. I will support the bill, although I think it should have been stronger. I've not gotten a lot of emails about it. I just believe in the basic civil rights of people, and I think that the demonizing of people who have different sexual preferences is what leads us to, and it's not a partisan issue, but it tends to lead people who believe in a political party to feel that they have to go into a closet or to sort of have conflicting behaviors, and therefore makes the whole issue more hypocritical. And if it was not so much demonizing by political parties of people who have different sexual preferences, perhaps we wouldn't have people behaving the way that they do and embarrassing them by virtue of them trying to hide their real identity. I think that rather than making it, it's an issue that is driven underground unnecessarily by the demonization of the so-called religious right.
This time, the next item of business before the committee are the amendments, the roll calls, which were called for and accepted and postponed. The first amendment will be, the first roll call vote will be on the Souder amendment to strike perceived from the legislation. The clerk will call the roll.
Chairman Miller.
No.
Chairman Miller votes no. Mr. Kildee.
No.
Mr. Kildee votes no. Mr. Payne.
No.
Mr. Payne votes no. Mr. Andrews.
No.
Mr. Andrews votes no. Mr. Scott. No. Mr. Scott votes no. Ms. Woolsey. No. Ms. Woolsey votes no. Mr. Hinojosa. No. Mr. Hinojosa votes no. Mrs. McCarthy. Mr. Tierney. No. Mr. Tierney votes no. Mr. Kucinich. No. Mr. Kucinich votes no. Mr. Wu. No. Mr. Wu votes no. Mr. Holt. No. Mr. Holt votes no. Mrs. Davis. Mrs. Davis votes no. Mr. Davis of Illinois. No. Mr. Davis of Illinois votes no. Mr. Grijalva. Mr. Grijalva votes no. Mr. Bishop of New York. Mr. Bishop of New York votes no. Ms. Sanchez. Ms. Sanchez votes no. Mr. Sarbanes. Mr. Sarbanes votes no. Mr. Sestak. Mr. Sestak votes no. Mr. Loebsack. Mr. Loebsack votes no. Ms. Hirono? Ms. Hirono votes no. Mr. Altmeyer? Mr. Altmeyer votes no. Mr. Yarmouth? Mr. Yarmouth votes no. Mr. Hare? Mr. Hare votes no. Ms. Clark? Ms. Clark votes no. Mr. Courtney? Mr. Courtney votes no. Ms. Shea Porter? Ms. Shea Porter votes no. Mr. McKeon? Mr. McKeon votes aye. Mr. Petri? Mr. Petri votes aye. Mr. Hoekstra? Mr. Hoekstra votes aye. Mr. Castle? Mr. Castle votes no. Mr. Souter? Mr. Souter votes aye. Mr. Ehlers? Mr. Ehlers votes aye. Mrs. Biggert? Mrs. Biggert votes no. Mr. Platts? Mr. Platts votes no. Mr. Keller? Mr. Keller votes aye. Mr. Wilson? Mr. Klein? Mr. Klein votes aye. Mrs. McMorris-Rogers? Mrs. McMorris-Rogers votes aye. Mr. Marchant? Mr. Marchant votes aye. Mr. Price? Mr. Price votes aye. Mr. Fortunio? Mr. Fortunio votes aye. Mr. Bustani? Mr. Bustani votes aye. Mrs. Fox? Mrs. Fox votes aye. Mr. Cool? Mr. Cool votes aye. Mr. Bishop of Utah? Mr. Bishop of Utah votes aye. Mr. Davis of Tennessee? Mr. Davis of Tennessee votes aye. Mr. Wahlberg? Mr. Wahlberg votes aye. Mr. Heller?
How's the gentlewoman from New York, Ms. McCarthy, recorded?
Mrs. McCarthy is not recorded. Mrs. McCarthy votes no.
Clerk will announce the vote.
Mr. Chairman.
Excuse me. Mr. Wilson.
Mr. Wilson's not recorded. Mr. Wilson votes aye.
Clerk will announce the vote.
Mr. Chairman, 18 members vote aye and 30 members vote no.
And the amendment is not agreed to. The next roll call will be on the Souter Amendment dealing with marriage. And the clerk will call the roll.
Chairman Miller.
No.
Chairman Miller votes no. Mr. Kildee.
No.
Mr. Kildee votes no. Mr. Payne. Mr. Payne votes no. Mr. Andrews. Mr. Andrews votes no. Mr. Scott. Mr. Scott votes no. Ms. Woolsey. Ms. Woolsey votes no. Mr. Hinojosa. Mr. Hinojosa votes no. Mrs. McCarthy. Mrs. McCarthy votes no. Mr. Tierney. Mr. Tierney votes no. Mr. Kucinich. Mr. Wu. Mr. Wu votes no. Mr. Holt. Mr. Holt votes no. Mrs. Davis. Mrs. Davis votes no. Mr. Davis of Illinois. Mr. Davis of Illinois votes no. Mr. Grijalva. Mr. Grijalva votes no. Mr. Bishop of New York. Mr. Bishop of New York votes no. Ms. Sanchez. Ms. Sanchez votes no. Mr. Sarbanes. Mr. Sarbanes votes no. Mr. Sestak. Mr. Sestak votes no. Mr. Loebsack. Mr. Loebsack votes no. Ms. Hirono. Ms. Hirono votes no. Mr. Altmeyer. Mr. Altmeyer votes no. Mr. Yarmouth. Mr. Yarmouth votes no. Mr. Hare. Mr. Hare votes no. Ms. Clark. Ms. Clark votes no. Mr. Courtney. Mr. Courtney votes no. Ms. Shea Porter. Ms. Shea Porter votes no. Mr. McKeon. Mr. McKeon votes aye. Mr. Petri. Mr. Petri votes aye. Mr. Hoekstra. Mr. Hoekstra votes aye. Mr. Castle. Mr. Castle votes no. Mr. Souter. Mr. Souter votes aye. Mr. Ehlers. Mr. Ehlers votes aye. Mrs. Biggert. Mrs. Biggert votes no. Mr. Platts. Mr. Platts votes no. Mr. Keller. Mr. Keller votes aye. Mr. Wilson. Mr. Wilson votes aye. Mr. Klein. Mr. Klein votes aye. Mrs. McMorris Rogers. Mrs. McMorris Rogers votes aye. Mr. Marchant. Mr. Marchant votes aye. Mr. Price. Mr. Price votes aye. Mr. Fortunio. Mr. Fortunio votes aye. Mr. Bustani. Mr. Bustani votes aye. Mrs. Fox. Mrs. Fox votes aye. Mr. Cool. Mr. Cool votes aye. Mr. Bishop of Utah. Mr. Bishop of Utah votes aye. Mr. Davis of Tennessee. Mr. Davis of Tennessee votes aye. Mr. Wahlberg. Mr. Wahlberg votes aye. Mr. Heller. Mr. Kucinich is not recorded. Mr. Kucinich votes no.
The clerk will report the
Mr. Chairman,
vote.
18 members vote aye and 30 members vote no.
The amendment is not agreed to. The next roll call will come on the Sauter Amendment, adding language to the retaliation provisions. Clerk will call the roll.
Chairman Miller.
No.
Chairman Miller votes no. Mr. Kildee.
No.
Mr. Kildee votes no. Mr. Payne. Mr. Payne votes no. Mr. Andrews. Mr. Andrews votes no. Mr. Scott. Mr. Scott votes no. Ms. Woolsey. Ms. Woolsey votes no. Mr. Hinojosa. Mr. Hinojosa votes no. Mrs. McCarthy. Mrs. McCarthy votes no. Mr. Tierney. Mr. Tierney votes no. Mr. Kucinich. Mr. Wu. Mr. Wu votes no. Mr. Holt. Mr. Holt votes no. Mrs. Davis. Mrs. Davis votes no. Mr. Davis of Illinois. Mr. Davis of Illinois votes no. Mr. Grijalva. Mr. Grijalva votes no. Mr. Bishop of New York. Mr. Bishop of New York votes no. Ms. Sanchez. Ms. Sanchez votes no. Mr. Sarbanes. Mr. Sarbanes votes no. Mr. Sestak. Mr. Sestak votes no. Mr. Loebsack. Mr. Loebsack votes no. Ms. Hirono. Ms. Hirono votes no. Mr. Altmaier. Mr. Altmaier votes no. Mr. Yarmouth. Mr. Yarmouth votes no. Mr. Hare. Mr. Hare votes no. Ms. Clark. Ms. Clark votes no. Mr. Courtney. Mr. Courtney votes no. Ms. Shea Porter. Ms. Shea Porter votes no. Mr. McKeon. Aye. Mr. McKeon votes aye. Mr. Petri. Mr. Petri votes aye. Mr. Hoekstra. Mr. Hoekstra votes aye. Mr. Castle. Mr. Castle votes aye. Mr. Sauter. Mr. Sauter votes aye. Mr. Ehlers. Mr. Ehlers votes aye. Mrs. Biggert. Mrs. Biggert votes no. Mr. Platts. Mr. Platts votes no. Mr. Keller. Mr. Keller votes aye. Mr. Wilson. Mr. Wilson votes aye. Mr. Klein. Mr. Klein votes aye. Mrs. McMorris Rogers. Mrs. McMorris Rogers votes aye. Mr. Marchant. Mr. Marchant votes aye. Mr. Price. Mr. Price votes aye. Mr. Fortunio. Mr. Bustani. Mr. Bustani votes aye. Mrs. Fox. Mrs. Fox votes aye. Mr. Cool. Mr. Cool votes aye. Mr. Bishop of Utah. Mr. Bishop of Utah votes aye. Mr. Davis of Tennessee. Mr. Davis of Tennessee votes aye. Mr. Wahlberg. Mr. Wahlberg votes aye. Mr. Heller.
How's Mr. Kucinich recorded?
Mr. Kucinich is not recorded. Mr. Kucinich votes no. Mr. Chairman.
Clerk will report the vote.
18 members.
Excuse me.
Oh.
I'm sorry, who?
Mr. Fortunio is not
Mr.
recorded.
Fortunio.
Mr. Fortunio votes aye.
Clerk will report the vote.
Mr. Chairman, 19 members vote aye and 29 members vote no.
And the amendment is not agreed to. The next vote will come on the Hoekstra Amendment dealing with the definition of religious organization. Clerk will call the roll.
Chairman Miller.
No.
Chairman Miller votes no. Mr. Kildee.
No.
Mr. Kildee votes no. Mr. Payne. No. Mr. Payne votes no. Mr. Andrews. No. Mr. Andrews votes no. Mr. Scott. No. Mr. Scott votes no. Ms. Woolsey. Ms. Woolsey votes no. Mr. Hinojosa. No. Mr. Hinojosa votes no. Mrs. McCarthy. Mrs. McCarthy votes no. Mr. Tierney. No. Mr. Tierney votes no. Mr. Kucinich. Mr. Wu. No. Mr. Wu votes no. Mr. Holt. Mrs. Davis. Mrs. Davis votes no. Mr. Davis of Illinois. Mr. Davis of Illinois votes no. Mr. Grijalva. Mr. Grijalva votes no. Mr. Bishop of New York. Mr. Bishop of New York votes no. Ms. Sanchez. Ms. Sanchez votes no. Mr. Sarbanes. Mr. Sarbanes votes no. Mr. Sestak. Mr. Sestak votes no. Mr. Loebsack. Mr. Loebsack votes no. Ms. Hirono. Ms. Hirono votes no. Mr. Altmaier. Mr. Altmaier votes no. Mr. Yarmouth. Mr. Yarmouth votes no. Mr. Hare. Mr. Hare votes no. Ms. Clark. Ms. Clark votes no. Mr. Courtney. Mr. Courtney votes no. Ms. Shea Porter. Ms. Shea Porter votes no. Mr. McKeon. Mr. McKeon votes aye. Mr. Petri. Mr. Petri votes aye. Mr. Hoekstra. Mr. Hoekstra votes aye. Mr. Castle. Mr. Castle votes aye. Mr. Souter. Mr. Souter votes aye. Mr. Ehlers. Mr. Ehlers votes aye. Mrs. Biggert. Mrs. Biggert votes aye. Mr. Platts. Mr. Platts votes aye. Mr. Keller. Mr. Keller votes aye. Mr. Wilson. Mr. Wilson votes aye. Mr. Klein. Mr. Klein votes aye. Mrs. McMorris-Rogers. Mrs. McMorris-Rogers votes aye. Mr. Marchant. Mr. Marchant votes aye. Mr. Price. Mr. Price votes aye. Mr. Fortunio. Mr. Fortunio votes aye. Mr. Bustani. Mr. Bustani votes aye. Mrs. Fox. Mrs. Fox votes aye. Mr. Cool. Mr. Cool votes aye. Mr. Bishop of Utah. Mr. Bishop of Utah votes aye. Mr. Davis of Tennessee. Mr. Davis of Tennessee votes aye. Mr. Wahlberg. Mr. Wahlberg votes aye. Mr. Heller.
How's Mr. Kucinich and Mr. Holt both?
Mr. Kucinich is not recorded. Mr. Kucinich votes no. Mr. Holt is not recorded. No. Mr. Holt votes no.
Mr. Chairman?
Wait.
Time to...
Clerk will report the vote.
Mr. Chairman, 21 members vote aye and 27 members vote no.
And the amendment is not agreed to. The Chair recognizes Mr. Andrews.
Mr. Chairman, I move that the Committee on Education and Labor report the bill H.R. 2685 to the House of Representatives.
The question is on favorably reporting the bill. All those in favor will say aye.
Aye.
All those opposed, no. In the opinion of the Chair, the ayes have it. The ayes have it. Mr. McKeon requests a roll call vote, and the clerk will call the roll.
Chairman Miller.
Aye.
Chairman Miller votes aye. Mr. Kildee.
Aye.
Mr. Kildee votes aye. Mr. Payne. Aye. Mr. Payne votes aye. Mr. Andrews. Mr. Andrews votes aye. Mr. Scott. Mr. Scott votes aye. Ms. Woolsey. Ms. Woolsey votes aye. Mr. Hinojosa. Mr. Hinojosa votes aye. Mrs. McCarthy. Mrs. McCarthy votes aye. Mr. Tierney. Mr. Tierney votes aye. Mr. Kucinich. Mr. Wu. Mr. Wu votes aye. Mr. Holt. Mrs. Davis. Mrs. Davis votes aye. Mr. Davis of Illinois. Mr. Davis of Illinois votes aye. Mr. Grijalva. Mr. Grijalva votes aye. Mr. Bishop of New York. Mr. Bishop of New York votes aye. Ms. Sanchez. Ms. Sanchez votes no. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. Sestak. Mr. Sestak votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Ms. Hirono. Ms. Hirono votes aye. Mr. Altmeyer. Mr. Altmeyer votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Mr. Hare. Mr. Hare votes aye. Ms. Clark. Ms. Clark votes no. Mr. Courtney. Mr. Courtney votes aye. Ms. Shea Porter. Ms. Shea Porter votes aye. Mr. McKeon. No. Mr. McKeon votes no. Mr. Petri. No. Mr. Petri votes no. Mr. Hoekstra. No. Mr. Hoekstra votes no. Mr. Castle. Mr. Castle votes aye. Mr. Souter. Mr. Souter votes no. Mr. Ehlers. Mr. Ehlers votes no. Mrs. Biggert. Mrs. Biggert votes aye. Mr. Platts. Mr. Platts votes aye. Mr. Keller. Mr. Keller votes no. Mr. Wilson. Mr. Wilson votes no. Mr. Klein. Mr. Klein votes no. Mrs. McMorris Rogers. Mrs. McMorris Rogers votes no. Mr. Marchant. Mr. Marchant votes no. Mr. Price. Mr. Price votes no. Mr. Fortunio. Mr. Fortunio votes no. Mr. Bustani. Mr. Bustani votes no. Mrs. Fox. Mrs. Fox votes no. Mr. Cool. Mr. Cool votes aye. Mr. Bishop of Utah. Mr. Bishop of Utah votes no. Mr. Davis of Tennessee. Mr. Davis of Tennessee votes no. Mr. Wahlberg. Mr. Wahlberg votes no. Mr. Heller. Mr. Holt is not recorded.
Excuse me, Mr. Holt.
Mr. Holt votes no.
Mr. Kucinich.
Mr. Kucinich is not recorded. No. Mr. Kucinich votes no.
The clerk will report the bill.
Mr. Chairman, 27 members vote aye and 21 members vote no.
And the bill is agreed to, and H.R. 2685 is favorably reported to the House. And the chair notes the presence of the quorum. The chair would also like to thank all members for their participation and their contributions to the markup. And I ask unanimous consent that the staff be authorized to make all necessary and technical and conforming changes to the bills reported by the committee today. In addition, I ask pursuant to House Rule 11, Clause 2I, that members have a requisite number of days to file additional or minority views on both bills reported today. Without objection, so ordered. Hearing none. You're going to have minority. Hey, 500-page max. Save a tree.